25 CV 16784, 24 CV 52569. Jill Bong versus Douglas County School District 15. Time is set for a hearing on I think there's a motion to dismiss citing discovery violations pending. There's several things that have been filed. I think what we're dealing with today is that motion, and then let me see what else we might be dealing with today.
I filed a motion to amend my answer, Your Honor. I believe that's up before the court.
You believe that that is not before the court? I do. I
believe it is.
Yeah, and there's a supplement to petitioner's motion for summary judgment. Request supplement. Okay, hang on a second. All right, so there are several filings that occurred in the latter half of November, and some that have continued into December. So let's start with Mr. Mergereau's motion for dismissal for discovery misconduct. Mr. Mergereau.
Thank you, Your Honor. I know the court will recall that we have had several hearings on this issue, and the issue is plaintiff refuses to produce the communications between whoever made the request and the school district that are at issue in this case. If the court will recall, we do not have the communications that constitute both the public records request itself and any response that was given by my clients, because all of this occurred so long ago. We don't have the email that occurred between petitioner or whoever made the request and that form the basis for her claims in this case. Plaintiff's complaint directly quotes not only from email between the requester and the school district, but responses by the school district. And this is on page 3 of her complaint. She quotes the secretary making a statement. She quotes the secretary making a second statement regarding the time spent on the request. She quotes the superintendent, who is no longer the superintendent, making email responses as well. And these are all in direct quotes, Your Honor. These are not paraphrases or summaries or anything. These are direct quotes. Plaintiff now says, or did say in response to what were 2 separate hearings on my motions to compel and 2 separate verbal orders by this court and a written order that was signed by this court in, I believe, October. She says, I don't have any of the communications except the original email between the requester and the school district. And that is what she produced. That is all that she is willing to produce. So we're in a situation where the court
what did you say she produced?
She produced a single email between Ronald Thompson and the school district, making the public records request at issue. She redacted Mr. Thompson's email address for reasons that are not clear to me. And then from there, she says, I have nothing else. And yet in her complaint, she is directly quoting from other email that she now claims she doesn't possess. So I am unable, and this ties into her summary judgment motion, Your Honor. If the court will recall, I filed an ORCP 47F response because I don't have the information. I don't have the documents I need to defend against that motion to make our argument in this case. And so I think plaintiff ought to be sanctioned by having this case dismissed for her willful refusal to produce discovery that she has to possess.
You said there was an order in October. I think I see one in August. Is that what you're talking about?
Yes, my apologies, Your Honor. August 5th, there is an entry. It says order on motion to compel, signed August 4th. The entry itself was created the morning of August 5th. That's the order that is being violated in this case. That order says she has to produce the documents.
Hang on, I'm going to read it. This says, the court being fully advised in the premises, it is hereby ordered that defendant's motion is granted and plaintiff is ordered to produce documents requested in defendant's requests 1 through 3, including all documents comprising the public records request at issue in this matter within 14 days of signing this order. And that was signed on August 4th of this year. And, you all can correct me if I'm wrong, but my recollection is that this was a defense at that hearing and that there was no signed motion at the time. And I thought I made it explicitly clear that my verbal ruling would constitute the orders necessary that needed to be complied with. And part of the reason I even went down that road in trying to remember it, and I haven't listened to the record to confirm that that's what I said. That was just my belief of what I said. But I read your response or opposition, Ms. Bong, and I think that what you cited was that there was no written order.
At that time, yes, Your Honor, and I have complied with the verbal order as you ordered, and I have produced, as Mr. Merzrow has filed in his declaration, that I have included the email between Ron Thompson and the school for the public records request. I don't know what other emails is referring to. I don't have anything else in my amended complaint. I don't quote any emails. I don't know what he's referring to.
Well, you said at that time, and I want to know what you are meaning by that, because in your opposition to the motion to dismiss that was filed in November, you said no inter-discovery order exists. So what?
As far as I know,
what do you?
I don't know what other order he's referring to. It was just that order that you issued in the hearing that I'll have to produce whatever emails I have in my possession. And I do have one, which was the one with Ron Thompson and the school, which I have already sent to Mr. Merzrow. So I don't know what else he wants that he claims that I quoted and I supposedly have.
Well, there is a motion. I mean, there's an order of, it's the entry date is August 5th, which is 2 months prior to your response, that says that you are to produce the documents requested in requests 1 through 3, including all documents comprising the public records requests at issue in this matter. So I want to know what it is that you're saying that there's no written order.
I don't recall receiving any written order for that order, Your Honor. But regardless, Your Honor, I have already produced what I have, which was the email between Ron Thompson and the school, which Mr. Merzrow himself has filed in his declaration to the court. So regardless of whether there's an order or not, or written or not, I have produced everything I have.
And Mr. Merzrow, you're saying that there is there an amended answer in this?
Does the court have access to the plaintiff's petition in this matter, Your Honor?
Is it the amended petition that you're referencing?
I'm looking at the original one, but I'm sure the amended.
Well, I'm going to go off the amended since that's the operable one, but tell me what it is that you're referencing.
But, Your Honor, it's actually the original complaint that is at issue here, because it's that complaint in which she quotes these emails from my clients to
what paragraph?
Paragraph 7, 9, and 10. And I want to start making...
Seven of the amended petition says the school was only able to quantify Cheryl Arp. The secretary had spent the total time researching this information was 40 minutes.
Right.
Is that okay? And then what was the other 7, 8, and 10?
No, Your Honor, I'm quoting from her original petition because that's where she makes quotes. That's where she literally quotes verbatim.
Well, what I just read was in quotes too.
In the amended petition?
Correct.
Yes, that's right. That is in quotes as well. So again, Your Honor, I want to start making a record on something, which is that Ms. Bong is being intentionally dishonest with this court. She is being intentionally dishonest with me. She knows exactly what email we are talking about. She knows exactly what written discovery order we are talking about, and she hides behind her pro se status to claim that she does not. And she needs to be held to account, Your Honor. I'm going to start making motions to this effect in this court and in all the other courts in which I'm defending cases against her. She is a litigant. Parties have some of the same, not all the same, but some of the same responsibilities that attorneys have in court. And one of those is candor. And that is not what we're seeing here.
Okay. Give me the other sections of quote that you were referencing. I got paragraph 7.
In the original petition, it's paragraph 8 and 10. Beyond that, I don't know that in the amended petition, and again, this is another example of what I'm talking about. She takes information and leaves it out of direct quote so that she can claim that she doesn't have the information to produce.
Ms. Bong.
So I don't know what Mr. Musro is referring to. The amended is the only one that's operative. The original is no longer operative, and whatever's quoted there is irrelevant. And the only 2 quotes I have in the amended is the one you quoted, which was paragraph 7, and I believe paragraph 4. No, that's actually a quote of the statute. One second here. I believe there was something else that was quoted in the amended, but I'm not sure.
So
where it is. There, in paragraph 5, I believe, and that I've already produced.
Mr. Mergero, what I'm reading from the original complaint says Cheryl Arp, the secretary, stated that the total time researching this information was 40 minutes. And when I read that, I don't know that it is a written document or something that's producible. So what is it that gives you the context necessary to understand that that is supposedly an email or a written communication?
It would be, Your Honor, if you look at paragraphs 9 and 10, these are not oral statements. These are written statements that are being quoted by the school district. I can tell you this, there is no such thing as an oral communication in relation to these public records requests. Everything is done in writing, and we simply do not have the writings that Ms. Bong's entire case is based on, and she refuses to produce them. I don't have information about where this information comes from because I don't have the records. We simply do not have them. And Ms. Bong obfuscates, refuses.
Ms. Bong, where is the document starting with paragraph 7 that Ms. Arp replied the total time researching this information was 40 minutes?
That's what Ron told me. I do not have that anything in written form anymore.
How was it communicated to you?
He might have told me, or he might have given it to me by email, but that's not something that I have anymore. But I do not have
So it
any
is-
direct communications with this.
It is a written communication. You're confirming that?
Most likely, yes.
How about paragraph 8? Or not paragraph 8, that's the policy. Paragraph 9?
That was so respondent nonetheless charged petitioner $40, which is what I paid, which is 11 times more than the $336. That's not a quote. That's just how much they charged and how much I paid.
As Ms. Arp stated, please understand the 40 minutes of time I personally spent on the project was for my time only. Other staff were involved in this particular research project. If you need further clarification in the matter, please contact the district superintendent, who is included in my reply. So that by itself indicates that it's a written communication. And so where is that?
I do not have that, and that's not on in the operative complaint, Your Honor.
Right, but I think we can revisit the original petition to demonstrate that there is something that is in writing that you should be. I mean, it's part of the basis for this suit that you've brought.
No, it's not, Your Honor. The basis of the suit is that the fee was unreasonable, not the email communications, Your Honor.
And paragraph 10, there's quoted language that says, in this case, there were several people who worked on this project, all at different pay rates, which exceeded the $40 cost that you have remitted. The district is not going to bill you for the extra costs. Where is that?
I do not have.
And Mr. Merzero, which requests are those documents or theoretical documents responsive to?
Request number 2, Your Honor, which asks for documents reflecting defendant's response to the public records request from any employee of defendant. And then number 3 also asks for any communications between she and defendant that are relevant to the public records request.
Okay. All right. Ms. Bong, anything else you want to say on the motion to dismiss?
Yes, Your Honor. Basically, the respondent is pretty much fabricating this so-called discovery sanctions. I do not have the so-called emails that I quoted, that he says I quoted in the amended complaint, which is the operating complaint. He's just trying to shift the burden on me for me to produce stuff that I don't have, and they themselves should have. They cannot shift the burden on me to produce that stuff. Those are the emails that they sent to Ron Thompson, and I do not have those emails.
Is there anything else?
That would
No,
be
Your
it,
Honor.
Your Honor.
Okay. Moving on to the motion to file the amended answer, Mr. Merzero.
Yes, Your Honor. This is a straightforward motion to amend. The only reason to deny a motion to amend is if it's so close to trial that it unfairly prejudices the other party. We don't even have a trial date in this case, so I don't see any reason to deny this motion. It simply clarifies the fact that it wasn't Ms. Bong that made the public records request in the first place. That was something that I learned after, as this case moved forward, and it reinstates the standing defense, which is appropriate based on that fact.
Ms. Bong.
Yes, Your Honor. This is prejudicial to me, Your Honor. I have already issued all my RFAs for this case. For the defendant decided he wants to amend the complaint. It reinstates the standing, as well as, I believe, another defense that the court has already stricken from the record, and now they're attempting to reinstate those defenses in this amended complaint. We have already established standing in the case, I paid for it, and therefore I have standing. And now the defendant's attempting to reinstate this issue after discovery has been completed, and we're ready for summary judgment.
Mr. Mergereau.
This is all news to me, Your Honor, and all the further reason why I need to be able to present a standing defense. If she is now arguing that because she paid the fee that she has standing, then I need to do discovery on that issue. And discovery is not closed. There's no close of discovery in state court, and there's no trial date. So discovery, unfortunately, as we just spent a few minutes discussing, is ongoing. And so plaintiff hasn't even tried to argue that there is unfair prejudice because of the timing. That's the issue here, Your Honor. And since there's no trial date, there can't be any unfair prejudice.
How is this prejudicial, Ms. Bong?
Because I've already used up all my RFAs, Your Honor, and he's trying to reinstate this standing issue. We've already covered this in one of the hearings that I paid for it, and therefore I have standing, and now he wants to reinstate the issue again. And not only that, it is on the burden of the defendant moving to amend that it is not prejudicial, not on me, Your Honor.
Mr. Mergereau.
Right.
What's the response to the request for admissions?
Well, Ms. Bong already moved for and was granted extra RFAs, Your Honor. I believe that was in this case. If not, she's certainly done that in other cases. The fact that plaintiff has used up all her RFAs is not a factor in whether or not to grant a motion to amend. That was her choice to do. She can always move this court again if she sees fit to increase the limit. And if that's appropriate, the court can make that order. These are really not related issues.
So I believe the request for additional RFAs was denied in this case. But anyways, Mr. Mergereau is right. We don't even have a trial date, and so there is no prejudice in this regard. And so, a motion with respect to leave to amend, the answer is granted. Mr. Mergereau to prepare the order.
I will. Thank you, Your Honor.
Okay. Let's deal with the objection to the characterization of trial format. Ms. Bong?
Yes, Your Honor. I've requested a jury trial. I have not agreed to a bench trial, and Mr. Mergereau has communicated with the court through your deputy that he believes that it is a bench trial. It is not a bench trial, Your Honor.
Why not?
Because I've requested a jury trial.
What entitles you to a jury trial in this case?
Requesting monetary relief, Your Honor, and there are factual disputes on that, on the case.
Where is the amended petition? Mr. Mergereau.
Well, first of all, Your Honor, this is not the proper pleading or avenue to bring this up. The ORCP 51 is the rule that deals with whether or not an issue is tried to a jury or to a court. I, of course, agree with, my position is that it's a bench trial because there is only equitable relief at stake and no money damages. The money that is at issue is in the form of the amount of a public records fee that is to be imposed on Ms. Bong in relation to these requests. The court ordering a particular fee is not money damages. Money damages are what get you to a jury, either that or an explicit right in a statute to have a jury trial. Public records cases are bench trials, flat out. And I can, at some point, Your Honor, if this continues to be an issue, I will make an ORCP 51 motion to that effect, and I can cite authority. But I don't think it's properly before the court on what Ms. Bong styles as a notice.
Ms. Bong, the claim for relief as stated in your amended petition are declaratory and injunctive relief. I guess, hold on a second, I lost. There you go. So they're declaratory and injunctive relief. How are those? Those are equitable claims. So I don't know. I'm not familiar with the right to a jury trial and claims of this nature.
Your Honor, it's not just equitable claims, Your Honor. I've requested a refund on the excess fee charge as well. So there are monetary claims as well.
Okay, take it under advisement. There is a motion or notice of clarification and request for judicial notice. What are you asking for there? There's a motion to okay, hang on a second. In that, you're saying that there's no signed discovery order appearing in the publicly accessible docket viewer.
Correct, Your Honor.
I'm not aware
of what order Mr. Mesro is referring to the extent that it was the oral order. I've already produced whatever I have. In terms of the order you read from August, I believe that's the one that I believe it's the oral on. If it's not oral and it's written, I do not recall receiving a copy of that. So in terms of Mesro's allegation that I violated the order, I have no exactly this order is that I have violated, because I have given him everything I have, Your Honor.
Mr. Mesro.
Your Honor, number one, her inability to recall receiving an order does not make her not subject to that order. Number two, I've shown in my motion that she was served with and opened the proposed order. That puts her on notice that the court is going to be considering that order. Number three,
Mr. Mesro, are you accessing the public domain when you are able to retrieve the order? You're looking at OECI?
Yes, Your Honor.
Yeah, and I believe you stated before I even said it was August 5th that order entry.
That's correct.
So, I mean, at the very least, I can't take judicial notice of it because it's not even true, Ms. Bong.
What is not true, Your Honor?
That there's no signed order with respect to the motion to compel, and that there's not one on the public docket or docket viewer.
I don't see anyone on the public docket viewer, Your Honor. It's the one that's publicly accessible. The OSCI is not publicly accessible, Your Honor. That is a paid service, and I don't have access to that.
The docket is the same, Your Honor. The pleadings and orders entered in the case file are entered in the case file, and they are viewable by different means, but they are the same entries.
The public view, the free viewing is not. I don't see any orders to it. It's just a summary of the order. I don't see anything else.
Okay. Well, there is a publicly accessible document that's been signed. Is what I'm saying.
If there is, I have no.
I mean, I'm not saying that I don't know what it is that you're referring to, Ms. Bong, but ultimately what I'm saying is that whatever you're looking at, to some extent it's not extraordinarily relevant because there is a document that is signed that is available to the public. And being the litigant in this matter, you are in charge of your case. And if you don't have the order, then you have the ability to request it from the courthouse. And I know that this was a matter that was extensively litigated. And I made, I believe, oral rulings that supported what is in writing also. So the motion, the request for judicial notice is Denied. And we're at the noon hour. There are a couple other matters that I perceive that we need a hearing on. The matters that we've already discussed, I'm going to take under advisement, and I get back to you with a ruling. Do we want to set up a quick hearing on these other matters?
Are you referring to the summary judgment, Your Honor?
Yeah, we don't have time to hear that today. I don't even know that Mr. Mergerol has. Oh,
Yeah, Your Honor, it's a supplemental memorandum. It's not a motion. It's not anything other than restating her position in the case. I don't know that a hearing is required, but if the court wants to have one, I'm fine with that, and I can prepare a response.
well, this thing is that this supplement is saying prompt ruling requested. So I'm imagining that it's intended to be a new motion.
Not necessarily, Your Honor, because there is a pending motion summary judgment in the case, and this is just to supplement what is already pending.
Is there a pending motion for summary judgment I'm unaware of?
Yes, there is. I believe it was filed very early this year, maybe in March or May. That's pending, and it was pending further discovery and further
It's for that.
adjudication
Okay.
of the factual allegations.
Understood. Okay. Mr. Mergerol?
And again, Your Honor, that's the motion I referenced earlier today that I responded to with an ORCP 47F because I don't have the information.
I think it's going to depend on what my ruling is with respect to Mr. Mergerol's motion. So let me wait through that, and depending on the ruling, we'll address the summary judgment issue. So for now, we'll hold the rest of this at bay, and I will address the standing issues. Actually, I think it's just the motion. Yeah, well, it's the trial format and the motion to dismiss that I have under advisement. I'll get back to you as soon as I can.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. Have a good day.
You as well.
You too.